Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is my Facebook page group, which is also called Foreclosure Help 777. And if you want to join us, if you're going through a foreclosure or about to go through a foreclosure, we're here to help you. So today we're going to talk about Carrington's case again. As you know, he's been fighting foreclosure for 16 years. He's in New York. Let's take a look at his case. If you go to the NYSEF, you can pull it up. His case number 11234-2009, Wells Fargo Bank, N.A. versus William Carrington. Okay, so the last things that were filed, let's take a look at. You'll see that Exhibit 180 is a notice of removal because he removed this case from state to federal court. And if you look up a little bit, you'll see the federal complaint that he also notified them he filed a complaint in federal court. That's separate from this one. And then you'll see that the judge issued an order that's dated 11/8/24. Let's take a look at that real quick. Okay, and you can see here, notice of removal. The notice of removal is ineffective as it is noticed some 15 years after action commenced in state court. Such circumstances requires a district court finding which is lacking herein. Trial shall proceed on the appointed date. And the trial date was set for December the 2nd, which is coming up, guys. So let's see what's going to happen now that that's happened. And as you can see, Carrington also filed a response to that judge's order, which is right here on 179, letter correspondence to judge, where he basically tells the judge, too bad, it's been removed. And we can just skip to the conclusion so we can get to the next bit. For the reasons set forth above, defendant respectfully requests that this court reconsider its order and allow the removal of this case to federal court to proceed. Should the court decline to reconsider its ruling, defendant reserves the right to seek further relief in federal court. Okay, so let's take a look at what's going on in federal court, shall we? Okay, now if you go to the PACER website, which for New York is the Eastern District, and you can see his case number 124CV7575, and you put it in the query up here where it says query report, and then you just hit run query. And here it is. There's his case number. There's the judge's date of last filing, 11/12/24. That was yesterday. Let's see what was filed yesterday. Okay, run query. Okay, you can see his complaint was filed on 10/31. The summons was returned, and then he filed yesterday a motion to consolidate the cases and an affidavit in support of motion. So what he's trying to do is consolidate his state court, which was removed to federal court, with this case. Let's take a look at his consolidation motion. Motion for consolidation of case number 124CV7575 and case number 124CV7775. Comes now plaintiff William Carrington, pro se, respectfully moves this court for an order consolidating the above captioned cases pursuant to Federal Rule Procedure 42A. In support of this motion, plaintiff states the following. Plaintiff seeks to consolidate two pending cases, the 7575 and the 7775. Both cases arise from the same core facts involving a foreclosure action, fraudulent conduct, and the validity of mortgage documents. Consolidating these cases will serve the interests of judicial economy, reduce the risk of inconsistent rulings, and prevent unnecessary duplication of efforts by the court and the parties. Factual background. Case number, ending in 7575, involves plaintiff's allegations of racketeering, forgery, and fraud against defendant PHH Mortgage and attorney Ronald Park of Henshaw and Culbertson. plaintiff asserts that these defendants engaged in a scheme to fabricate and forge mortgage documents to wrongfully foreclose on the plaintiff's property. Case number ending in 7775, which is the removed case, arises from a foreclosure action initiated by Wells Fargo Bank N.A. as trustee for the Soundview Home Loan OPT 2007 OPT1 Trust, care of PHH Mortgage Corporation in state court, which defendant successfully removed to federal jurisdiction. Carrington asserts defenses based on the fraudulent and forged documents involved in the foreclosure process. The same documents at issue in case number 1 are central to the dispute in case number 2. Both cases involve substantially similar facts, including the same parties and the same core issue of the validity of the mortgage documents that PHH Mortgage and their attorney Ronald Park of Hinshaw Culbertson relies upon for foreclosure. Additionally, the legal theories of fraud, forgery, and counterfeiting and potential violations of federal laws such as RICO overlap in both matters. Legal standards for consolidation. Federal Rule of Civil Procedure 42A provides that the court may consolidate cases if they involve a common question of law or fact. Rule 42.8 states, if actions before the court involve a common question of law or fact, the court may join for hearing or trial any or all matters at issue in the actions, consolidate the actions, or issue any other orders to avoid unnecessary costs or delay. And determining whether to consolidate, courts generally consider the following factors: whether the cases share common questions of law or fact, whether consolidation would promote judicial efficiency and convenience, whether consolidation would prejudice the parties. Argument. Common questions of law and fact. Both cases involve allegations of fraud, forgery, and misconduct related to foreclosure of plaintiff's property. Case number 1, plaintiff alleges that PHH Mortgage and attorney Ronald Park counterfeited and forged 3 different promissory notes and other mortgage documents to initiate a wrongful foreclosure. In case 2, Carrington challenges the validity of these same documents in the context of a foreclosure action. The central issue in both cases, the validity of the mortgage documents, requires the resolution of overlapping factual and legal issues. Courts routinely consolidate actions where the underlying issue are substantially the same. And then there's case law here. Alright, so they're attaching case law to prove the point. Similarly, in the air crash disaster of Florida Everglades, the court noted that consolidation is proper when cases involve the same parties and the same subject matter. Judicial efficiency and economy. Consolidation will streamline the resolution of these related matters. It will prevent the duplication of efforts in discovery, motions practice, and trial preparation. Furthermore, it will minimize the risk of inconsistent rulings on the same parties, particularly regarding the alleged fraud and forgery of the mortgage documents. As the court stated in Miller v. U.S. Postal Service, consolidation under Rule 42A is appropriate when it will avoid unnecessary costs or delay. Here, consolidating these cases will avoid the necessary repetition of fact-finding and legal analysis across multiple proceedings. Consolidation will promote the efficient use of the judicial resources as the court can address all issues related to the mortgage documents in a single proceeding. This will help avoid multiple trials on essentially the same issues, a practice that promotes the interest of the judicial economy. No prejudice to the parties. Consolidation will not prejudice either party. Both cases involve the same underlying facts, and the parties are already engaged in litigation over these issues. In Hall v. Hall, the U.S. Supreme Court held that consolidation is appropriate when it does not prejudice the parties or lead to undue delay. Here, both parties were already involved in the same legal disputes regarding the mortgage documents, and no party will be unfairly burdened by consolidation. The court emphasized that consolidation promotes efficiency by eliminating unnecessary duplication of efforts and ensuring that the cases involving common questions of law and fact are adjudicated together and avoiding inconsistent rulings. The same principle applies here where the court's resources will be utilized more efficiently by consolidating these two cases. Conclusion. For the foregoing reasons, plaintiff respectfully requests the court grant this motion for consolidating case number ending in 7575 and case number ending in 7775 pursuant to the Federal Rule of Civil Procedure 42A. Consolidation will promote judicial economy, avoid unnecessary duplication of effort, and ensure consistent rulings on the issues central to both cases. Respectfully submitted, William Carrington. Okay, so that's what he submitted in the docket here, as you can see. And he also submitted an affidavit in support of his motion to consolidate the cases. So we'll see what the judge decides. The other case, the 7775 case, he also, we can't view it yet because it's not in PACER, but he also filed a motion for a writ of mandamus and a motion for a TRO, temporary restraining order, because this upcoming trial that is in the state court, the judge will not cancel that. So if you file a writ of mandamus telling the, basically it's the federal court telling the state judge that he's out of line. Once a case has been removed from state court to federal, it's no longer in state court. So we'll see how that goes. Anyway, guys, if anybody has any questions, you can leave them in the comment section below. As always, I hope everybody has a wonderful day, and thanks for watching.